If you or a loved one have been charged with a misdemeanor offense in Tarrant County, specifically a Class B or Class A misdemeanor, here's what to expect when you go to court. The first court appearance is appropriately called the initial appearance. And the initial appearance has two purposes. First, for the court to make sure you have an attorney, and second, to add any additional bond conditions the court deems necessary for your case. What that means for most misdemeanors is as soon as your attorney sends in a letter saying they represent you, you will likely be excused from that initial appearance. And that's because most misdemeanor cases don't require any additional bond conditions beyond what you were given when the magistrate saw you at arraignment. However, in those cases where you were released from custody before seeing a judge, which is a rare occurrence, or in the situations where the judge has an additional bond condition. For example, the blood alcohol concentration on a driving while intoxicated case coming back at a 0.15 or greater means the judge is now going to impose a condition that says you have to have an interlock device installed on any vehicle that you drive. That's an example of when you would have to go in for your initial appearance. However, even in those cases, if the conditions are satisfied before the initial appearance date, you will likely be excused from that court setting. From there, the misdemeanor courts will set your case for a number of settings. These settings are generally a month apart or approximately a month apart. The first setting is something along the lines of a consultation setting, where you will go in with your attorney will speak to the prosecutor, to the court coordinator, to the judge, and then come back out and talk to you to give you an update on the status of the case. At our firm, we have generally been proactive, the only exceptions being where the prosecutor hasn't gotten back to us. So as long as the prosecutor has gotten back to us, has opened up the evidence or discovery on your case, you will know before that first court setting whether this is going to be a substantive setting or whether you're just checking in and you're going to be released in a reasonable amount of time. Generally, misdemeanor court settings won't take more than a morning. Sometimes they'll be as short as an hour. It really depends on how many other cases are set that day, and in this either tail end or post-pandemic world that we're in now, court settings are more limited. They don't have as many people coming in at a given time. So it's more likely you'll get out closer to an hour rather than 4 hours. But also understand that there's a system that the courts expect the attorneys to follow. Felony courts have to be attended to first, and even within the misdemeanor courts, certain courts have preferential settings on any given day, which means an attorney first goes to the felony courts and then misdemeanor courts. And if you have a misdemeanor setting, you may have to wait a while. It's important for you to show up on time. The judges know the attorneys are in the building and are working their way through the courts if they have multiple settings that day. So your primary job when you report for court is to show up early. That way you can get through the security line, get up the elevators that are limited right now because of the pandemic. There's only 6 people per elevator. Getting to the appropriate floor, finding the appropriate courtroom, and checking in. You'll need plenty of time to do that. Additionally, parking around the courthouse can be difficult to find. There is street parking, and there's parking at meters, but those fill up fairly quickly. The additional parking structures are multi-level, so you'll have to, again, take stairs or an elevator down and get over to the courthouse. So you want to give yourself plenty of time to do that. So your first and primary job is to be there on time. Your second job is to make sure you check in however the courts want you to check in. So that's sometimes checking in with the bailiff, that's sometimes answering the docket or roll call that the judge or judge's coordinator calls out. Some judges want you to answer with your name, some judges want you to answer by raising your hand and saying you're present, or standing up and even giving your attorney's name. So be prepared for that. Other than those two things, being on time and answering the docket or checking in appropriately, you will have no further interaction with the judge or prosecution or anyone else unless your attorney has told you otherwise. Of course, if you show up late, then you are going to be called in front of the judge, and there may be some questions about that. Additionally, the judge can hold your bond insufficient for being late. So again, be on time, check in, and then wait for your attorney. Subsequent court settings in misdemeanor courts are going to be very similar. Your attorney will have given you an idea of, is today the day the case is going to be resolved, or are we still working on it? If your case is going to be resolved, you will go through paperwork either at the time or before you get to court. That paperwork will be submitted to the judge, and your attorney, of course, will walk you through everything you need to know about appearing before that judge. Our general advice when coming to court is don't do anything that's going to draw attention to yourself, especially negative attention. So don't wear anything that's ripped, torn, has an offensive graphic on it. You don't have to go to the other end of the extreme and go out and buy a new outfit for court. As long as your demeanor and appearance shows the court respect, you're going to be fine. It can be a button-down shirt, it can be a collared t-shirt, anything that shows the court you're taking this seriously. Going above and beyond is not really going to set you apart. Of course, this is different if and when your case goes to trial, and your attorney will talk to you about what you should wear at a trial setting. So these preliminary settings will continue on a misdemeanor case until you reach something called a status conference or an announcement setting. And what this means is the case has been pending for a while, and the judge expects that the parties have had enough time to potentially resolve the case. So the announcement you're going to make is, are we going to trial, or is this case going to be resolved, ideally by the next setting? For misdemeanor cases, that entire process can take 6 months, it can even take a year, or again, because of the pandemic, it may take longer than a year. But whenever you get to that status conference, if you cannot resolve your case, the case is then placed on the contested trial docket. From that moment on, every court setting is a potential trial setting, and your attorney will have to appear ready to go to trial. The one additional type of setting that you'll see in family violence cases, particularly in County Court number 5 in Tarrant County, is a motions docket. And this is a precursor to getting to trial. At the motions docket, the judge expects both parties will have filed any appropriate motions at least 10 days before the docket, so that the judge can hear essentially pre-trial motions before cases get to trial. And what's unique about Court 5 is that it is, and for a long time has been, the primary family violence court, although now Court 1 has been added to that docket. And for that reason, more cases end up going to trial, and the judge wanted to create greater efficiencies to make sure people aren't waiting to have their motions heard on the day of trial or on the eve of trial. If you have any questions about your upcoming court setting and you're a client of ours, be sure to reach out to one of us. We'll be happy to answer any questions you have, as mundane as where's the best place to park, all the way through what should I expect at my next setting.